Here's an interesting lecture, part of the lecture about the primary objective of copyright laws. And when I ask this question in a live class, the answer is all the time, to reward the author of all the work he did, and not necessarily correct. So let's start with an hypothetical, because maybe you can identify with the situation a little better. Assume you are a student in a Marketing 1 class. Your team project, a marketing proposal for a new product is terrific. After you give a presentation of the class, compete with Microsoft PowerPoint, and visuals and pop musical interludes, you receive the first A of your college career. 6 months later, you discover your idea was even better than you thought when you watch your own marketing plan in action on a local cable television. Your teammates are as excited and also disappointed as you are. And what can you do? It was your presentation. You used PowerPoint slides. Everything was your voice, you name it. So that's where we go into copyright. What is copyrightable then? Is it the particular way in which an idea is expressed? And whenever an idea and expression are inseparable, the expression cannot be copyrighted. Please remember that. It is a particular way in which the idea is expressed. So it's the expression of that idea that is copyrightable, and not necessarily the idea. Are compilation of facts copyrightable? Well, according to Section 103 of the Copyright Act of 1978, defines a compilation as a work formed by the collection and assembling of pre-existing material or data that are selected, coordinated, or arranged in such a way that the resulting work as a whole constitute an original work of authorship. Big words. The key requirement in the copyrightability of a compilation is originality. So it's not so much what you're using as much as what you do with it. Again, is that expression. And I want to share this because this was interesting before we go into the net in cyberspace. In 1991, in the FICE publication Inc. case, the white pages of a telephone directory do not qualify for copyright protection when the information that makes up the directory, such as names, addresses, and telephone number, is not selected, coordinated, or arranged in an original way. And what really in the case really was happening is this guy is approaching different company to have the directory. And of course there was one, Ruler was the only company that refused to license its listing to FICE. They just did it. So next thing you know, this guy had a whole list of names, but there were a bunch of names missing because Rural company did not want to give them the list of names. So he decided to take it without their permission. And he used the listing without their consent. And this is where happened then, of course, Rural then sued the company for what? For copyright infringement. And according to the court, they says, no, there is no copyright infringement, because he was taking names and phone numbers and address and directory, and he was setting it up a whole different way. Therefore, it was the originality of the expression of those names and address and telephone number that it's copyrightable, but not the names and directory. And according to the court, the raw facts may be copied at will. Only the compiler, selection, arrangement may be protected. It is the means by which copyright advances the progress of science and art. Here we go again. It's what? The means by which copyright advances the progress in science of art. We have a new way of having a telephone directory. The result is neither unfair or unfortunate, the court said. It is the means by which copyright advances the progress of science and art, and not to reward the labor of the authors. In 1993, there was another Bell South Advertising and Publishing Corporation where even the yellow pages of a telephone directory did not qualify for copyright protection. To be protected, a work must be fixed in a durable medium. Think of the internet now. Your drive, you'll see it, from which it can be perceived reproduce, or communicate it. Protection is automatic. Registration is not required. Copyright laws makes a distinction between reproduction for public use, which you need consent, and private use. And the question comes, do we have private use in the internet? Copyrights then also controls only the first sale of a particular work, but not any subsequent sale, and is limited by national boundaries. That is, to distribute a CD in one country does not automatically include the right to distribute in another. Please remember this, because going into ebooks, which I'm not going to cover, something for you to go back to this before you make a decision. Therefore, what is copyrightable? The answer really is any information can qualify for protection if its limited availability gives it economic value and it is reasonably guarded. And of course, the next question is, what is reasonably guarded? Is it a password? Yes, a password can be reasonably guarded. Do you change the password every day, once a month? That means you reasonably guard that information and has economic value to you. And I don't mean just of economic because of money, like you can sell your message, for so much money. It's economic value to you, sentimental, it's private, it's personal. It values to you that you don't want everybody else to have access. Of course, you have copyright infringement. Whenever the form or expression of an idea is copied, an infringement of copyright has occurred. Whenever, now remember that, whenever. The reproduction or derivative work does not have to be exactly the same as the original, nor does it have to be reproduced, the original, in its entirety. If a substantial part of the original is reproduced, there is copyright infringement. Those who infringe copyrights may be liable for damages or criminal penalties. Just to let you know how serious this is situation. These range from actual damages or statutory damages. The statute tells you what's your damages. Imposed on the court discretion to criminal proceeding for willful violation. Did you really intend? Because ignorance of the law is no excuse. And you cannot say, well, I did not know, I just did what I was told to do. So this is something for you to really take to heart. Exception to liability, of course, for copyright infringement is made under the fair use doctrine. Over and over again, when it comes to copyright situation infringement, you're going to see that the defendant will use freedom of speech. I have, especially going into the internet. And then the next thing they're going to say, fair use. I'm using it fairly. I'm not using it to make money. I'm not using it to become rich. I'm using it for the good of society so that they have more knowledge and they make better decisions. And that's the word fair use doctrine come. The courts determine whether a particular use is fair or is fair on a case-by-case basis. So you might think it's fair, but then by the time you go to court, the court doesn't think it's fair. Thus, anyone reproducing copyrighted material may still be committing a violation and you don't even know you are. And here is a very interesting case in your book about the fair use doctrine. And again, we're talking about still, in the old-fashioned way of disseminating information without database and without the internet. So at the heart of the case, which is in your textbook, is a claim by Alice Randall, author of TWDG, that she made only fair use of GWTW. That sounds interesting. You'll see it. The book is very good in explaining what that means. The appellate court wrestled with the legal doctrine and favors the publication of Alice Randall. That means there was fair use. Why does the court find that Randall made a fair use of GWTW? Judge Birch writes that the copyright clause and the First Amendment, while intuitively in conflict, were drafted to work together to prevent censorship. They were working together to prevent censorship. So if the company is saying that you cannot reproduce that material, they're really telling you censorship. you cannot do something, that means you don't have your freedom of speech, you don't have your freedom of information. And of course, I would like to know, what do you think judge meant, and does it mean the same thing to you? Please answer these questions on the discussion board, because this is something that I would like to see how you apply the purpose of these laws to the questions. These laws are important because the nature of the internet requires that data be copied to be transferred online. So this is why, before we go to the next part, I really want to make sure you understand the purpose and what kind of information is copyrightable. And again, remember, any information that has some kind of economic value to you, and it's reasonably, not without a doubt, just reasonably protected. Thank you.